My name's Casey Stewart. I'm born and raised in actually Fort Myers, just a little south of here. So that's where I'm located. I do work for Beacon Point. I came on with Beacon Point about 3.5 years ago, and was in private practice for about 8 years prior to that, doing estate plans and probate and trust administrations. I know what you're asking. Why did you put someone that looks different up there? When I grew the beard out, I asked my wife if I should keep it. She said yes, so guess who won that battle? Yep, so I've done hundreds of probate and trust administrations and estate plans over the years. And working for Beacon Point, I get to work with clients all over the country, giving them advice and recommendations. I have a team with me. We are located all over. Our strategic and legacy planning department is the department I'm in, and we have multiple attorneys around the country that help out with our clients. And we advise on your estate plan and help give you recommendations and things like that. So let me move on. All right, today we're just going to go over some very basic estate planning items and things to think about. If you already have an estate plan, hopefully maybe it'll just bring up something that you maybe want to update or ask your attorney questions about. But I'm just going to go over some very general, very basic things regarding estate planning. So the base estate plan. What's an estate plan? An estate plan is something, it's a group of collective documents that in a very short terms are planning to distribute your property and your assets, but also care for yourself and your children upon incapacity and death. So a lot of people sort of forget, and a lot of people think of, oh, last will and testament. Everyone's pretty familiar with that document. But a lot of people fail to realize that you might need help while you're still alive. And so planning for your incapacity and people who are going to make your decisions for you when you're unable to. So who needs an estate plan? Basically anyone with children, especially minor children, but anyone who cares about how and whom the assets pass, anyone with substantial wealth, and anyone wanting a say in their own care upon incapacity. Going back up here to the one on the top right, anyone who cares about how and whom the assets pass. If you do not have an estate plan, you don't have a will or a trust, then the state law actually takes over and tells you who's going to receive your assets when you pass away. What if you don't have an estate plan? Well, there's many other things that go with this, but like I said, I'm going to keep it basic. But you kind of lose control of who receives your assets. I just kind of mentioned that. State default rules apply. Who the court appoints to take care of your children. Again, that's kind of referring to minor children. But how assets are used to take care of your children. So that means kids of any age. You can have control and decide when and how your children receive your assets. It's much more difficult if you don't have an estate plan to have the key people in your life care for your kids if something happens to you, and also assist you upon your incapacity or death. All right, why people fail to plan. It's a lot of times uncomfortable to talk about. Nobody wants to talk about it, but it's something that is important and needs to be done. So uncomfortable with thoughts of death. You're unsure who to appoint in key roles to make your decisions. So some people's situations are different. Some people have children and spouse, obviously, to make decisions for them, or good friends and family. But others don't. Others don't have people around, so who am I going to use to make those decisions? And that's something that you would talk about with the attorney. You're unsure of time and cost it's going to take. It is going to take time a little bit to get your estate plan in motion, and it will cost money, but hopefully if you get the right attorney, it won't be that bad. And you're unaware, some people don't plan because of, we say government's plan in here, but really that means change in laws or updates to laws, just like our recent tax law legislation, some people will wait because they feel like something's going to change and they'll never do anything, and then something happens to them and they never planned. So we never really want to wait on anything like that. You want to go ahead and establish your estate plan and then update it if needed. Okay, so I know we have some like patients in here and caregivers. I think this slide's really applicable. Does the caregiving spouse need a plan too? And the answer is definitely yes. What if the caregiver passes away first or needs care themselves? So in private practice, we commonly had people come in with Alzheimer's, beginning stages of Alzheimer's, dementia, Parkinson's, anything like that. And one spouse was the caregiver, and we would do estate planning. But they originally would bring the client to us for the ill spouse and planning for that. But then once we brought up, they didn't think about what if something happened to them first, what was going to happen. So we would also put that plan in place as well. Because, and you'd be surprised, it's not often, but you would be surprised that the caregiving spouse does happen to need assistance or pass away sooner sometimes because they are spending a lot of time giving care, and sometimes they neglect their own health. So we have to plan for both situations on who's going to pass first. You could do a whole nother presentation there on Medicaid and long-term care planning, so I'm just going to touch on it a little bit. But there are attorneys out there that specialize in elder law, which is Medicaid eligibility and planning. A lot of people think that you have to have no assets in order to qualify for Medicaid. However, that's not true. You can qualify for Medicaid with even a substantial amount of assets if done properly. So that is something to look into if you feel like you're going to need help paying for care in the future. And long-term care insurance. Obviously, that's based off of eligibility and multiple factors, diagnosis, etc. But if you still have the opportunity to look into long-term care insurance, that is important. For example, my father is in memory care right now. He's got bad dementia, doesn't really know who anybody is anymore. But luckily, they got long-term care insurance prior, and while he was still able to get it. And it doesn't cover the whole facility, but it definitely helps because it is expensive. So look into those things to help in the future because that can also be helpful. All right, some things that we typically look for or look into or consider when doing an estate plan would be, who are you planning for? Are you married? We're planning for a spouse, children. Do you have a blended family? Are you on a second marriage and both of you have separate children, or separate children and then you have some children together? All of those situations need some specific planning to handle all those dynamics. Do you want family and friends involved in your estate plan? We also would look at the type of assets. So we're going to look at your personal property. That's things of value that are collectibles, maybe artwork, any collections, jewelry, things like that that are valuable that don't have titles to them. We're going to look at all of your accounts and how they're titled, your retirement accounts, 401k, IRA. We're going to look at your real estate and any other assets you may have. I know there's other stuff out there now, cryptocurrency and all that, but we're going to take all that into consideration when looking at the planning. And we're going to look at how do we transfer the property, or how is it currently set to transfer, and do we need to make any changes to that? So do we want to transfer it to your assets to your beneficiaries by will, trust, beneficiary designation, transfer on death designation, or right of survivorship? These ones down here on the lower end with the orange star, these assets actually usually transfer outside of your estate plan, outside of your will or trust, so they will transfer upon your death directly to whoever is on your beneficiary designation. So we're going to look at all that and tie it all together and make sure everything flows together. All right. I think you're going to be more interested in this part. These are some of the documents that you would get in the base plan. So I'm going to go through them a little bit here and explain. Also, I forgot to mention, if you have questions, write them down. We'll have time at the end to answer, and then I'll also hang around a little bit at the end if you want to maybe ask a little bit more personal question. But getting back to it here, everyone's, like I said, it's pretty much heard of a last will and testament. So you can have a will, and the will would nominate guardians for any minor children, nominate your executors or personal representative who you would have handle your estate when you pass away, and distribute the property at your death to your beneficiaries. So you can have a separate will and no trust, or if you do decide that you want a living trust or that's appropriate for your situation, you will have a trust that will distribute property outside of probate. So if you have just a last will and testament, you will have to go through probate. So it's the process of the court process of proving the will, and then the court oversees the administration and keeps tabs on everybody and makes sure that the beneficiaries get their inheritance. But if you have what's called a living trust or a revocable trust, those assets that you title in the trust actually pass outside of probate and aren't subject to court oversight. It still will distribute your property however you want it to your beneficiaries, and it will also provide instructions on how you would be taken care of if you become incapacitated. If you have a living trust or a revocable trust, up there in the top right it says will or pour-over will. If you have a trust, you would still have what's called a pour-over will, and it's essentially a safety net. The pour-over will says, if at my death, if there's anything that's left outside of my trust, it's going to go to the trust. So basically, it makes the trust the beneficiary of your will. I know it's very high level, and I can answer more questions if you have specific questions at the end regarding these documents. Another would be a power of attorney for financial matters. Sometimes it's referred to as a durable power of attorney, financial power of attorney. That appoints your agents to handle financial matters. And anything that you would be able to do outside of making medical decisions. So basically, your agent under your power of attorney, financial power of attorney, can step into your shoes and do anything else except for healthcare decisions on your behalf. Then there's the healthcare directive. Sometimes that's called a healthcare power of attorney, an advance directive, something of that in that nature. That appoints your agents to make your healthcare decisions for you if you're unable to make them. There is one that's not listed on here that you may have also heard of before. It's called a living will. That document, in that document, you tell your doctors and your agents how you would like to be treated in an end-of-life situation. Do you want medicine to feel comfortable? Do you want food and water? Do you want everything? I call it the pull the plug document. So basically, it's like, do you want them to keep you living or let you pass away once you meet certain criteria and you have no chance of recovery? So that sometimes is a separate document called a living will, and then other times that may be incorporated into your healthcare directive. The next one is a HIPAA authorization. HIPAA is, if you haven't heard of it, is a federal healthcare privacy act. And that protects your healthcare information from other people getting it without you authorizing it. So sometimes this is a separate document, and you can list the people in it who you want to be able to obtain your healthcare information, talk to doctors, things like that. Sometimes it is incorporated as well into your healthcare directive, and we'll have the same language in there. I like it being separate, a separate document, because you may want to put other people on there that you haven't put in your healthcare directive. So you might have certain people that you want to make your healthcare decisions. And then you might want to have other family members that aren't going to make your healthcare decisions, but you do want them to be involved and maybe help get information, things like that. All right, so frequent problems with estate plans. All right, forgotten assets. So many times people would come into our office and they would already have an estate plan set up, but maybe they moved down here and wanted to review it, or it's been a while since they've looked at it, so they'd bring it in for review, and we'd get to looking at it, and we'd find out that there were forgotten assets. So assets they kind of forgotten about, and meaning that they likely had a trust, and these assets weren't funded properly to the trust, which sort of would defeat the purpose of the trust because it wouldn't work the way they had planned. A lot of times those assets were, business interests, real estate, and then also assets acquired after creating the estate plan. So somebody would create their estate plan, set it all up properly, but then years later they might sell their home, buy another home, change banks, and when they did all that, they didn't set it up properly in the trust name and things like that. So it would take it out of their estate plan essentially. Outdated players, and what that means is your agents, the people you've chosen to help you and make your decisions. So sometimes those people get outdated. They pass away. You're no longer close with them. They're older and just won't be able to do it anymore. Maybe you had friends and family on there while your children were younger and you didn't think they were responsible enough, but now they're older and definitely responsible, and you maybe want to switch them out and put your children in there as decision makers. This third one here doesn't necessarily apply to Florida as much, marrying couples as joint tenants. We are a common law property state, not a community property state, so I'm going to skip over that because it doesn't really apply to Florida. Improper beneficiaries. So some people will get their estate plan set up, and then the beneficiaries on their IRAs, their life insurance, anything like that, then may not match what their estate plan, their will, or their trust says. So that's one thing the attorney would help you with, or should help you with, is taking everything together and making sure that it's set up to work together. And then outdated trust provisions. So if you do have an estate plan and you haven't looked at it in a really long time, there may be stuff in there you want to update that you didn't even realize you wanted to update. But changes in your financial situation, different family dynamics, things like that may need to be fixed in your estate plan. All right, some top client questions that we get sometimes. Is it time to update your estate plan? I know I'm repeating on some of this a little bit, but if you have a major life event, it's definitely time to at least take a look at it. When we say update your estate plan, it doesn't necessarily mean things have to be done, but it might need to be done. So death, divorce, marriage, birth of a child, grandchild, you move states. Different states have different laws regarding this stuff, so I have another slide on this later, but usually when you move states, you want to have your estate plan reviewed in the new state that you move to, because not that it won't be valid anymore, but there may be some differences in the state law that need to be updated in there as well. So a change in wealth, so you gain a lot of assets, or vice versa. You maybe had to spend a lot on your care or something like that, and your assets have diminished some. Time to reevaluate at that time. And then also, I've mentioned it before, new assets that are not, weren't transferred to the trust if you have a trust. Change in your health, a change in the law. So as we know, we just had tax change with the administration, so sometimes that can affect your estate plan depending on your net worth. And then the passage of time, we always recommend reviewing your estate plan about every 5 years. Doesn't mean you need to do anything or actually make changes to it. It just review it to make sure that it is still the way you want it. What is the planning process like? So usually in the first meeting with the attorney, You'll talk about some things like how do beneficiaries receive property. You'll obviously talk about who you want to make your decisions, who your beneficiaries are, but then you're going to get into some deeper conversation of how do they receive it. Do your children inherit it equally? The age that you want them to inherit it. Do you want them to control their inheritance? Is there concerns about their ability to handle it? Do you want the inheritance protected from creditors or spouses of your children? Also, if one of you was to pass away, people don't like to think about this, but there are times when a spouse may get remarried, so there are protections you can put in place for that if you have children to protect the assets from a new spouse. How and who carries out your wishes, who makes the financial and healthcare decisions on your behalf, who would want to serve as guardians for your children if under 18. In the second, and then there might be some follow-up meetings. I would say it usually takes 2 to 4 meetings to establish your estate plan and get it completely completed. After you have that first initial meeting, the attorney will usually draft the documents. You'll have another meeting to review them. Assuming it's appropriate, you might sign in that meeting or maybe another meeting. And then if you have a trust, they should assist you with titling your assets according to the plan that you did, which means transfer assets to the trust. What should you share with your children? So, like I said, I've handled hundreds of probate administrations after people pass away. I'd say the thing that hurt families the worst in regards to argument after someone passed away or the parents passed away was the lack of communication that they had. So no one knew anything, and a lot of people will have in their mind what they think is going to happen or what they think their parents would do, or how much they think they might get, and then comes to their surprise that it's not set up the way they thought, and nobody knew. So there ends up being some disagreements there. So I do think it's important with sharing at least basic information with your children, your estate plan, especially if there's different roles that each child might play in the estate plan, and explaining why and who's doing it, things like that. The more you share, the more you will avoid, emotional strife, especially if the treatment of children is not equal. Consider a discussion about that, because a lot of kids think it's just going to be equal, but maybe you supported one child more during their life, and maybe you want to then make it up to the other two at death, so you give that child that you supported more a little bit less upon your passing. Those children tend to think that they still should get an equal share. So having that discussion ahead of time, though, so they know what to expect. Different terms for different children. Other thing I would say, the next one, an existing loan, that's what I was going to touch on. Sometimes parents will give their children a loan to maybe buy a house. If no one else knows about that loan, then when you pass away, that loan may disappear, and that child may get a windfall again if you leave everything equal. So if everyone knows about the loan and there's a balance on it, whatever share goes to that child that has the loan would be subtracted by the loan balance, and so everyone gets an equal share. And then also, if you plan on leaving inheritance to an unexpected person, maybe a friend, a caregiver, a charity, somebody that is kind of unexpected, I would go ahead and let the other people in your estate plan, especially your children, know about that, so they, like I said, they manufacture some stuff in their heads about what's going to happen, and if something's unexpected, they tend to not like it. So also, talking to your children about the estate plan and what they're inheriting. Some of them lack the understanding and impact of the inheritance and how it will be handled. They know maybe that they're going to get something, but they don't know if they're getting it outright. They don't know if it's going to be held in trust for them, if they're going to be able to manage it or not. A lot of kids aren't prepared to manage wealth. They've never had, a large sum of money. So when they do receive it, how do they handle it? And if you have a financial advisor, we always at Beacon Point recommend that the advisor and their client, we get the kids involved so that the advisor can then help with the transfer and help the kids as well so they don't, blow it on whatever they're going to spend it on. All right. How can I distribute assets to protect my children? So if you have concerns, maybe you have a child who has a spending issue, or you're concerned about it, you don't like the child's spouse, that's common, then there's things you can do, like leave them in trust for your children. You can protect. Having a trust set aside for your children when you pass away, it can have potential protection from creditors and upon divorce. It retains wealth in the family, so you can say, I'm going to leave you your assets in trust, and if the child passes away, I then want it to go down to their children. Where the trust benefits there is, if the assets stay in trust, you can control how they pass down to even your grandkids. Whereas if you just say, here, child, here's your assets, take it, you can do whatever you want with it. Now it's up to their estate plan, and now it's subject to creditors and possibly their spouse and things like that. So a trust would help with that. It might avoid estate taxes on the assets at their death. So when you keep assets in trust, as long as they don't remove them out of the trust, let's say you have a child who ends up being independently successful in their own way, and they might have an estate tax issue, so they're wealthy. The money that you leave them wouldn't be incorporated into that. It would be left outside of their estate. They would still have access to it, but it wouldn't be calculated in their estate when they die to pay federal estate tax. And you also have the ability to choose the trustee who manages the money in your child's trust. You can have the child do it, and you can have a friend or family member. You can have a corporate trustee or a bank. There's lots of options. This happens a lot in Florida. So, do I need multiple plans or sets of documents if I live in multiple states? So Florida, we've got a lot of people, maybe some of you, who live somewhere else, decided to come down here, move, retire, but you still have your house up north. That's great. But the answer is no, you don't need documents in both states. You want to have documents in the state which you are domiciled, so which you plan on living. So most people would choose Florida for that because of our favorable laws. So most people move here and establish domicile and then split their time, as long as you guys have probably all heard, as long as you spend a little more time in Florida, you're okay. There are factors to establish domicile. You can look them up very easily online. There's probably 10 to 20 of them. You do not have to do all of them. It's a totality of the circumstances. So there are some that hold more weight than others, but some would be filing a declaration of domicile in the county where you live, updating driver's license, registering the vehicle here, registering to vote, changing your doctors, your mailing address, everything to Florida. You basically want to make it look like you live in Florida, even though you may split your time. But your documents in Florida still should be valid and be able to use throughout the other states. But even if you pass away while you're at your home up north, because you are domiciled in Florida, your estate would still be handled in Florida and under Florida law. And vice versa. If you technically live somewhere else and you came to Florida as your part-time residence, your estate would be handled in the other state there you technically lived. What if I own real estate in another state? So you still got your two houses. You've established Florida as your domicile. We're going to look at ownership considerations. Is it owned jointly? it's owned jointly, it will pass to the surviving spouse immediately upon death. But we typically, in that situation, would recommend a trust, because if you pass away with real estate in your individual name in another state, you have to do an administration in Florida and a probate administration in that other state where the real estate was located. So in that situation, we would want to do a trust for you and deed the up north property into the trust so that you do not have to do probate in that other state. That's a big deal. It's a pain to do both. All right, what happens if a spouse or loved one passes? We do understand it's a very difficult time. You don't need to do anything drastic immediately, but these are just some suggestions. There's obviously many other things, but within the first few days or weeks, you want to notify your attorney, accountant, financial advisor, and any institutions so that those people can start helping you and with the transition. You want to compile records, get death certificates. Usually the funeral home will help you with the death certificates. They'll ask you if you want them to order them. You can tell them how many you want to order. There are two types of death certificates. There's a long form. It contains the cause of death. And then there's a short form which does not contain the cause of death. And you should get at least a few of both. Some institutions like the long form and some want the short form. And then you want to compile any creditors that the decedent might have had, because those will usually need to be taken care of at some point. Within the first few months, you might have a trust or probate administration, which would be your estate plan working and being put into place. The asset division in that, the retitling of assets, any tax filings or payments that need to be done, any time-sensitive retirement plan choices. I won't really go into that, but that would be something a financial advisor or somebody could help you with. And then time-sensitive estate moves. Again, there are certain things you have to do or make a selections on within a certain period of time, but it gives you plenty of time. Even within the first few months, you would be fine. And then about 6 months out, again, this is approximate, you'd want to revisit your financial plan because you probably have changed. If you're a surviving spouse, you have changed needs, a changed income potentially, a new perspective, determine proper use of the assets now, and then you might want to either create a new plan or maybe make adjustments to your current plan. So if you're married, you should it should be drafted to where everything is set up to go all the way through if both of you pass away. But occasionally when a spouse passes away, sometimes you may want to update the key people, remove the deceased spouse off, add somebody new in. Doesn't mean the entire plan's changed. You may just want to make some little tweaks here and there. All right. And then advanced planning, so I am almost finished. I'm not going to go into much advanced planning because that really is very subjective compared to what your needs are. But the main reason advanced planning is needed is when you do have a large estate. Currently, Florida, as you all know, does not have any state inheritance or estate tax, but the federal law does. That exemption is $13.99 million per person. So what it's saying is you can pass $13.99 million as of 2025 to anyone tax-free. And if you're married, that comes out to $27.89 million. Most people obviously don't fit into that category, but this would be when you would want to look into advanced planning if you are close to this, over it, or around this area. If you do have anything over that amount, you are subject to paying tax on 40% of the amount that's over it. So it turns out to be quite a bit. We do know that the One Big Beautiful Bill Act that was just passed by this administration has changed the exemption. It was set to move actually lower in 2026 to about $7 to $8 million per person, but they've actually made it higher. So in 2026, it will be 15 million per person, 30 million per married couple. So there are lots of strategies out there if you meet that, in which you can plan to not still pay tax on it. That is it. I hope I didn't go too fast, and I hope that was helpful. Is there any questions or anything? Sure. Me or your question? Oh, okay. No worries. Sure, that's a great question. So for the people online, he asked, what's the difference between a will and a trust? So a will, they both will still pass assets to your beneficiaries, okay? And they both will still choose who you want to handle that. The difference between a will is it goes through probate. Probate is a court procedure. In Florida, there's two different types, but in Florida, the formal administration usually takes 6 months to a year. And it can be more costly, obviously. And then you have to provide the will to the court, so it does become public record, and the court basically oversees the process. It still will get to your beneficiaries the same, but a trust stays out of probate. So anything that you have titled in your trust does not have to go through that probate process and will not be overseen by the court. You still should have an attorney help you with it afterwards, but typically it's quicker and less expensive for everyone involved after you pass away. That's the short version of it, but the main thing. But again, that goes also back to if you have real estate out of state, the things that are titled in the trust don't have to go through probate in that other state either, so it will all be handled here. Does that help a little bit on a high level? Okay, good. Any other questions? Sure, go ahead. Medicare or Medicaid? Medicaid. Yes, it can. There's federal requirements and then state requirements as well. There are strategies to qualifying. The sooner you start that planning, the better. There's what's called a 5-year look-back period. So people think that just because they have some money, they can't qualify for Medicaid. Well, they can. It's just there's a process in transferring the assets out of your name. And there's many different strategies for that. So the sooner you do that, the sooner you can actually, if you do the proper planning and in time, you can still preserve your assets and pass them on and have Medicaid step in and pay for care, or pay for part of the care and then have your assets last longer, things like that. So. You could. If you've already have one domicile selected, I would go with that one first and do that. I would say Florida's pretty good about it. A lot of people do that type of planning here. So I'd start, if here's where you're domiciled, then I would start here. Basically what Medicaid comes down to is you can only own so many assets and you can only have so much income. And it's pretty low. A married couple can have more, but there are strategies to transfer the assets to either your spouse or other people, different trusts and things. Did I answer your question? Okay, good.
So
yes.
When do you do that? You said you start planning early on that.
Yes.
How do you know 5 years out what it's going to be like?
Yeah.
How do you really start that strategy?
So the first question was regarding, I'm talking to the people online, sorry, about Medicaid and eligibility, and if you need to talk to an attorney if you live in multiple states. That was my answer just a minute ago. The new question is, what if you don't know what it's going to be like in 5 years after the look-back period? Is that right? Okay, so what?
When do you start that process?
Well, the process would start as soon as you made the transfer of assets outside of, to somebody else. So as soon as you made those gifts, that's when the period starts. So then because if you go to qualify for Medicaid, you have to give them everything regarding your finances essentially. So they will look back and see, well, this money got transferred out. So, but as long as it goes past, as long as you go past 5 years, it no longer matters anymore. If you, let's just say you end up needing Medicaid sooner, let's just say halfway through, there's usually what's called a penalty period. So you would get penalized a certain amount, and you'd have to pay for a certain amount of your care, and then Medicaid would kick in. That's a very generalized, but you would essentially, you still could qualify, but you would be penalized and have to pay for it's an equation. A month, it goes by how many months you need it early and things like that. So you would essentially pay for a certain period of time, and then Medicaid would step in and start paying.
And how do you transfer those assets? Like, how does that happen?
Well, there's many different strategies. I'll just kind of.
So that's different than setting a trust, right? Even though you have a trust, this is another process?
It can be, but actually this can take the place of your estate plan because they'll do it all in one. It actually will be everything together. It'll be the Medicaid planning and your estate plan all in one. So actually, like if you have concerns about care in the future and you want to look into Medicaid planning, go talk to the elder law attorney. You don't need to do both, and they will actually they'll do everything together. Because part of the planning will actually be different types of trusts that you will set up that will handle when you pass away and things, but it will be specific to how the assets need to be handled for Medicaid. So it'll all be tied together. Does that make sense? I know it is confusing. I'm trying to make it simplified, but it is very complicated. There's a lot of rules regarding Medicaid.
If you already have a trust with one attorney, then you need to see another elder law attorney.
Yeah, if your current attorney does it, they might already do it. A lot of estate planning attorneys might already do that, but some, it is sort of a specialty, so some don't. So yeah, if you go see elder law or Medicaid attorney, you can type those in and you'll get a lot of, or ask your attorney if they do it or for a referral. Any other questions? Great question. So we were asked, is a will or a trust required by law? The answer is no. So if you don't have one, that's where Florida law would step in, and the law actually would dictate where you're at, who would receive your assets, and also the court would choose who's going to handle your estate. Now, likely it's your family. They're going to go to the court and say, hey, I'll do it. And the court will say, yeah, we need someone. Go ahead. Yeah, so if you don't have a will or a trust, you are definitely going through probate, no matter what. Mm-hmm.
So if I have a brother and my brother and I decide this is what was in my mother's and my father's estate, and you can have this much and I can have that much, and we agree, do we need to go further with the law in order to take care of that?
Yes, you would. Because you won't have any authority to handle or transfer those assets to you. The court appoints a personal representative, the person who's going to handle the estate, and they give them a document from the court, and that document has to be given to banks and institutions, and they will only work with you if you have that document from the court. So if somebody passes away and you aren't a joint owner or a beneficiary, just like in your scenario, you and your brother and your mother passed away, if you weren't a beneficiary, it was just in her name, you walk into the bank, they're not going to talk to you until you have that from the court. Now, if you're a beneficiary or a joint owner, then you can. You'll get it right away. They'll transfer it to you.
You go in and if you're on the will and you go into the bank and they'll see that you're on the will, the trust, then you can go ahead and manipulate and take that money and be
Shouldn't be able to. Not saying the bank won't make a mistake, but I will say that they are pretty good about not doing that because that's how they've got sued in the past. So if you have a will and you just walk in and say, hey, I'm on the will, they still won't work with you until you have that document from the court that authorizes you to handle the assets. So I'm not saying that it's never worked that way, but if it did, it was a mistake. They usually are pretty good about that, not doing that. Yeah. So we were talking about a will there or probate, yes. So if you're the trustee. So if you're so say you pass away and your kids are the trustee, however you set that up, and the account is titled in the trust, so the trust owns it, they can walk right in and say, you know, prove they're the next trustee, show your death certificate, and then work with the bank. Yeah. I'm not allowed to give direct legal advice here, but yeah, if you have a joint account, it would transfer to them automatically. However, most estate attorneys will recommend that you don't do that with your kids because once you put them on, you can't get them off without their signature, and also it subjects them to your creditors and you to theirs. So if you're joint on an account and it has a lot of money in it and they get in a car accident, now they're half owner on that account. And now your account that you share with them could be subject to a lawsuit. So there's a few reasons why we don't recommend putting them on, but you can do a TOD or POD, payable on death or transferable on death. It's like setting up a beneficiary on the account. They don't have access to the account. They're just a beneficiary if you pass away, and they would go directly to them. Yep. Anything else? Yes. You would have, if you have a trust, you would have the pour-over will. Yep. That is basically a safety net. It's only saying if I accidentally leave something out of the trust, and it does have to go through probate, it's going to go to the trust and be coupled with everything else and then distributed together. So it's basically just a safety net there so that it's handled better, essentially. You guys have great questions. So I'm not repeating them I'm forgetting for the people online, so I do apologize about that. Sorry, go ahead. That's a loaded question. So he did ask is there a max age or where it gets too expensive for long-term care? Is there a point when that takes place? That's subjective to every person and the company who's offering it. They're gonna do the application, take the health, and then look at the whole thing and make that determination. Obviously, the older you are and the more issues health-wise you have, the more expensive it's going to be if they offer it at all. But the earlier you do it, the better chance you have. So did that help? Sorry, I don't have exact numbers on that. It's all based off of the different companies and their requirements and everything. Mm-hmm. Yeah, I don't have, I really don't even have good, it's all over the place. Honestly, yeah. I would say overall, yes, but I would say at the same time, it depends on the total financial situation. So what was asked, I keep forgetting to tell the people online, was would I recommend long-term care for everyone? General answer, yes. However, there would be situations where, depending on the financial situation, it may not be worth it. But that's where, like, if you do have an advisor, it's helpful to have them do a financial plan for you and have them say, if you do live this long, this is what your money's going to do and cover. And then they can then take long-term care insurance and add that into the plan and show you the difference of how long your finances will last with the long-term care insurance. That's something that we do, but any financial advisor should be able to do that as well. Good questions. Anybody else? Oh, you're welcome. Thanks for having me. All right. Well, I'll hang around just for a few minutes if anyone thinks of any other questions, but it was a pleasure, and you're welcome.